Hi, my name's Hugh Southey. I'm a barrister based in London at Matrix Chambers. I specialise in refugee and asylum law as well as human rights law. I have a particular interest in cases where an individual faces allegations that they are a threat to national security. If you want details of my practice or my chambers, go to matrixlaw.co.uk. Okay. What I'm going to be talking about today is the impact of national security concerns on the treatment of refugees, asylum seekers, and people in a similar position. In essence, in the United Kingdom at least, the current sort of scheme of treatment and the current sort of scheme of taking fairly draconian steps against refugees commenced in 2001 following the 9/11 attacks. At that stage, Tony Blair, who was then Prime Minister, made a particularly memorable comment about how, in light of 9/11, the rules of the game have changed. Now, what he meant in relation to that was that the state was willing to take far more draconian action against people who were alleged to have been involved in terrorism-type activities. In practice, one of the primary targets of that action were people who were either refugees or asylum seekers. Such people obviously have relatively limited political muscle and are, as a result, particularly vulnerable to state action. What in fact has happened is that there have been really three forms of action taken. The first form of action taken was indefinite detention without any prospect of removal. That system of indefinite detention failed for reasons that I'll come to in a minute, and was preceded with, and it was followed rather by a system of deportation with assurances that a person wouldn't be at risk of ill treatment. Again, that system largely failed for reasons I'll come to, and has been followed by what is basically the current system, which is a system where individuals are denied significant benefits like a travel document if they are deemed to be a threat to national security. Now, I'm going to look at each of those schemes in detail and what the legal challenges were. The first scheme, as I already indicated, was essentially indefinite immigration detention. It was indefinite because it was aimed at people who couldn't be removed from the United Kingdom, in general because if they had been removed they would be at risk of ill treatment. Legally, what was supposed to have happened, although it was ultimately held to have been unlawful, was that the United Kingdom was supposed to have derogated from Article 5 of the European Convention on Human Rights in relation to foreign nationals who couldn't be removed. Now, it's important to recognise that this scheme only applied to foreign nationals. I make that point because ultimately the primary reason why the scheme was found to have been unlawful, at least domestically, was because it discriminated against British nationals who were allegedly involved in terrorism. British nationals couldn't be subject to indefinite detention, foreign nationals could. Domestically, as I've already indicated, that treatment was rejected as being unlawful discrimination, and in particular, and this is probably the most important principle established by the case, it was held that discrimination was prohibited because, despite the government's argument to the contrary, migrants who couldn't be removed were in an analogous position to British nationals. Now, that's an important principle. It was established, as I say, domestically. It was established by the House of Lords in a case called A in the Secretary of State for the Home Department, 2005, 2 appeal cases 68. But the reason why it's important is it does unusually put foreign nationals, particularly refugees, in an equivalent position to British nationals. The case did proceed to Strasbourg, and Strasbourg added in some senses to the protections that were provided, or the protections that are offered to refugees, in that in the United Kingdom, the Strasbourg court established that because liberty was an issue, there were minimum standards of disclosure required, so that an individual was entitled to be told of the case against them in sufficient detail that they could provide instructions. The effect, essentially, of both of these cases, particularly the domestic case on discrimination, was that the scheme came to an end. And since it came to an end, there's been no attempt to reintroduce a sort of similar scheme, obviously because, in part, it would be politically unacceptable to seek to detain British nationals. What then happened was that there was an attempt to deport people to countries where they would be at risk of ill treatment on the basis of either assurances or memorandums of understanding. Assurances are essentially individual agreements about a particular case that a person won't be ill treated. Memorandums of understanding are essentially bilateral agreements between states that anyone being removed won't be ill treated. Both sets of agreements are supposed to be backed up with schemes for monitoring potential allegations of ill treatment. However, it's pretty obvious that there are good reasons to be concerned about such schemes. If a country has failed to comply with its international obligations to prevent serious ill treatment and torture, it's pretty difficult to see how that country can be trusted generally. If it's got no track record of compliance with agreements entered into at treaty level, why should it comply with other agreements? There is another, perhaps less obvious reason why these agreements cause concern. Almost inevitably, these agreements are reached on the basis of secret negotiations. Governments are very reluctant to disclose who's been involved and what promises have been made in return for a memorandum of understanding or an assurance. And yet it's highly likely there will be material offered by the United Kingdom to persuade a state to issue assurances. For example, why would a state like Algeria, who were one of the countries who issued assurances, offer assurances if the only thing they're going to achieve by offering assurances is the return of people who were allegedly involved in terrorism? Algeria has no interest in adding to the number of alleged terrorists it has within its borders. So it is quite important to know what was offered in the negotiations, because that's one way of testing out the reliability of the assurances. But the government is very reluctant to disclose that sort of material. Despite these concerns, the European Court of Human Rights has essentially accepted that assurances may be lawful, albeit it's generally scrutinised them with a degree of care, and in practice has often found them unlawful. For example, in Sardi in Italy, application 3720106, the European Court of Human Rights clearly did not rule out the possibility of assurances being lawful, but rejected the particular assurances because it felt that they were not specific enough to address the particular risks that arose in that case. Domestic courts have tended to adopt a similar approach. For example, in RB versus the Secretary of State, 2010, 2 appeal cases 110, the conclusion that was reached by the domestic court was that everything depends on the circumstances. So one has a situation where it is important for those representing asylum seekers to challenge the reliability of the assurances, but as I've already indicated, the problem is that the government doesn't want a representative to be provided with the material that allows them to challenge the assurances. What the United Kingdom has done to attempt and I wouldn't accept it's very satisfactory, but to attempt to ensure that the assurances can properly be challenged, is establish a right of appeal to the Special Immigration Appeals Commission. The Special Immigration Appeals Commission is an unusual body because it's expressly established to enable the court to consider material that is not disclosed to the migrant or the asylum seeker. Its basic problem is Rule 4 of its procedural rules, that essentially provides that national security can be a trump card in these circumstances. Now, the government would argue that there are other safeguards in place, and in particular, they would argue that the presence of a special advocate who represents the interests of the asylum seeker in the closed proceedings is a safeguard. But it was recognised by the Court of Appeal in a case called W in the Secretary of State for the Home Department, 2010, EWCA Civil 898, that ultimately the procedure that was being adopted would not meet standards of fairness established by the common law. Despite that, the European Court of Human Rights has upheld procedures before SIAC, most recently in a case called IR in the United Kingdom, 14876/12, a case which was primarily about Article 8, but probably applies in an Article 3 context. And it applied it essentially on the basis that migrants enjoy fewer procedural rights, or rather approved SIAC on the basis that migrants enjoy fewer procedural rights. The one ray of sunshine in this area is the fact that obviously refugee law in the United Kingdom is now governed by EU law. For example, Council Directive 2004/83 EC, the Qualification Directive, defines who is entitled to refugee status. And the importance of refugee status in European Union law is made clear by the recognition of a right to asylum in Article 18 of the Charter of Fundamental Rights. Now, the important point about the application of EU law is that EU law gives rise to procedural rights. Article 47 of the Charter of Fundamental Rights is an express right to a fair hearing. Article 47 has been interpreted by the Court of Justice as meaning that an individual is entitled to a minimum level of disclosure. That was decided in the case of ZZ versus the Secretary of State, 2013 Queen's Bench Reports 1136. ZZ, it's fair to say, is primarily a free movement case, but given it is based on Article 47, it's difficult to see why it wouldn't apply in other EU contexts, particularly when Article 41, or the equivalent of Article 41 that arises as a result of fundamental principles of EU law, has been applied in an asylum context in the case of MM and Ministry of Justice, C27711. The reality of this is that in any case where asylum is an issue, or humanitarian protection or an equivalent right under EU law, it is probably correct for an individual to argue that they're entitled to minimum levels of fairness as a result of Article 47 of the Charter. That issue hasn't really been considered domestically, in part because most of the cases where deportation with assurances were sought are now very old cases. The reality that the United Kingdom has discovered is that because these cases do involve very difficult procedural issues, they take a very long time to determine and are resource intensive. The reality is very, very few people have been removed from the United Kingdom on the basis of diplomatic assurances. So the United Kingdom's most recent approach is essentially not to try and deny people refugee status or protection where national security is an issue, but to try and deny them benefits associated with that status. So, for example, there are cases of travel documents being refused, There are cases where people who've been recognised as refugees and then sought to obtain citizenship have been denied citizenship. And there are cases where people who were initially citizens have lost their citizenship. Those cases are still at a relatively early stage, and so it's a little more difficult to assess whether or not this will provide the benefits to the state that it seeks. But again, the primary problem the state has now faced is that in many of these contexts it's been possible to rely on European Union law, and it's been possible as a result to rely on ZZ to ensure that there is a minimum level of disclosure, which is often what the state resists. Some cases it's obvious why EU law applies. The most obvious situation is where, for example, a travel document is refused. A travel document is a right provided for in the Qualification Directive. Article 25(1), sub-article 1 of the Qualification Directive provides for that. But in other areas it's a little more difficult to establish a right to EU law. And perhaps the most significant development in recent months in the United Kingdom has been the decision of the Supreme Court in FAM and the Secretary of State 2015 One Weekly Law Report 1591. In that case, the Supreme Court questioned whether EU law applies to decisions to deprive people of their citizenship. The reason for that essentially was that the Supreme Court were doubtful as to whether or not the United Kingdom ever intended to surrender any rights in relation to citizenship decision making. That's important because, again, it is essentially in the context of people who were formerly refugees that deprivation of citizenship is most likely to be an issue. Deprivation of citizenship will only be an issue where somebody has another citizenship. But the problem with the United Kingdom's approach is that what it's now doing is essentially undermining the integration of people who initially started as refugees and then became citizens, because such people are faced with the reality of a situation where if they leave the United Kingdom there is a risk that they will be deprived of their citizenship. And it's a risk that also that they will and there is also a risk that they will be denied a fair trial, because at the moment the ZZ approach hasn't been applied in cases where people are being deprived of their citizenship. The overall effect of what I've just described in this short video is that the United Kingdom has taken some fairly draconian action against refugees in particular who are said to pose a threat to national security. Those steps have been in practice of limited benefit to the state because lawyers have been relatively successful, but the consequence of that is that the United Kingdom has continued to attempt to develop new means of limiting the rights of refugees and asylum seekers. Thank you. I hope that's of interest, and as I say, if you want to know any more, please contact us at Matrix Chambers. Website again is matrixlaw.co.uk. Thank you.